Hello and good afternoon, everybody. My name is Ross Pitcoff of the Pitcoff Law Group. We are a commercial litigation and corporate boutique law firm located in New York City on 48th and Park Avenue. And today we are going to be speaking about minority owners and rights and partnerships. We'll be focusing on legal protections, disputes, and strategic remedies. So just a quick backdrop and a little review about us or our firm. We are a corporate litigation and corporate transactional boutique, once again located in the heart of New York City. A lot of our litigation focuses on claims arising out of breaches of contract, on claims arising out of fraud, and very importantly, we tend to focus on a lot of partnership disputes. And anytime you're dealing with a business divorce, a minority shareholder oppression claim, whether it be coming from the plaintiff or defending against one on the defense side, tends to be in the mix more often than not. Moving along with the slides. So as for today, starting off, we will focus firstly on legal protections from minority owners. We will then discuss minority oppression and litigation and how that functionality plays out. We'll talk a little bit about valuations and buyouts when we're dealing with scenarios involving oppression claims. We will then also talk about judicial and procedural remedies with respect to oppression claims. Then we will consider more of that corporate transactional side of things, focusing on drafting protective agreements. And finally, strategic risk assessment is something that we will consider for how to ensure that we can be best protected when dealing either with minority owners of companies or as the minority owners when dealing with the majority owners of companies. So first and foremost, just a little bit of backdrop. So minority shareholder oppression claims are rather important. When things go sideways in any type of business-oriented setting, it tends to happen and escalate really, really fast. So when we get into the CLE, we're really going to be focusing on spotting risks early, understanding the tools that you have at your disposal as a litigator or as a corporate transactional attorney drafting operative documents, and deploying strategies before damage becomes irreversible. So minority oppression isn't a hypothetical thing. It's happening in businesses that likely your clients own or invest in. And whether it's a partner getting frozen out or profits are quietly being diverted, we tend to see these disputes escalate rapidly, especially when rights are not clearly understood or enforced. So why do these rights matter? Well, again, when you're dealing with an oppression claim, it's very important to know that as a minority owner, you may not have the decision to impact voting significantly. You may not be involved in the day-to-day of the business's operations, but nevertheless, it's always important to remember that as a minority, you have certain protections that always are going to be afforded you under the law. So who's in the room with respect to these types of claims? Well, you tend to have, number one, attorneys for the minority owners. You tend to have counsel for the majority owners. Sometimes you have separate company counsel that, for better or for worse, can get dragged into one of these situations and scenarios. And then you often have advisors and consultants. And those can really run through a litany of different advisors. Those can be CPAs. It could be financial advisors. Perhaps it's a controller or a CFO. It certainly could be a forensic expert with respect to litigation. So the whole panoply of who's involved tends to vary. But no matter what, you'll have counsel involved, and then you tend to have a number of other more expert-oriented individuals. Okay, so how do we define a minority owner of a company? Now remember, for those of us who aren't overly familiar with these processes, when you're dealing with a corporation, you are operating under the Business Corporation Law in New York, known as the BCL, and those individuals are called shareholders. When you're dealing with a limited liability company, the New York LLC law applies, and in those situations, we call the individual owners members. And there's nuances to get into with members and managers, and if an LLC is manager managed or member managed, but for our intents and purposes today, we don't really need to dive too far into that. So when I mention minority shareholder oppression, technically shareholders are for corporations, but this type of theory applies to limited liability companies and partnerships as well. But a minority member claim, I will tend to kind of use this term sort of interchangeably. So let's define a minority owner. Number one, a minority owner is one that has less than controlling interest in the company. So kind of very clearly stated, if they're under a 50% owner of the business, so 49% or less, they're going to be considered a minority owner. And also, a minority owner will lack unilateral decision-making in general. So a minority owner is anybody holding less than a controlling stake in a corporation or an LLC. Understanding this definition becomes key because the legal protections available often hinge on whether an owner is considered a minority under the law. Okay, so let's focus on the legal landscape here. Before we even get into the ring, we have to kind of understand the rules. And when we're dealing with claims that arise out of minority shareholder oppression, I can tell you that 9 times out of 10, you will also see other associated claims. Now, some of those claims can fall under statutory authority, for example, the limited liability company law that we just referenced, or the business corporation law. They can also fall under contractual law. So we have an operating agreement, and the operating agreement affords the minority certain rights, and those rights are being violated, so therefore we're setting forth a claim arising out of a breach of contract. The statutory authority can also be something that we rely upon. We're seeking judicial dissolution because it is simply not possible to continue to operate this company, and under the BCL or under the LLC law, we have a statutory right to dissolve. Then there's fiduciary claims, and those tend to kind of bring us into the universe of the common law creations. So a minority shareholder oppression claim is actually sort of akin to a fiduciary claim. Fiduciary claims, of course, are an elevated responsibility and role that one partner in a company has to another, or that the members that are the majority have to the minority, and vice versa. And a minority shareholder oppression claim is very similar in that regard. So when we think of the legal landscape, we think about contractual issues, which tend to deal with shareholder agreements, bylaws for a corporation, or an operating agreement for an LLC. We tend to think of statutory authority, the business corporation law, the limited liability company law, and then we think of those common law creations, which we're going to get into in more detail as we move along forward. Okay. So fiduciary duties of majority owners. Now, when we're dealing with these corporations or we're dealing with these LLCs, there are certain duties that are owed from one to the other. So fiduciary duties are the great equalizer in close corporations and LLCs. Even without express contractual terms, the law imposes obligations of fairness, of loyalty, and care. And so breach of these is the #1 claim in oppression cases. And now walking through the ideas of the duty of loyalty, the duty of care, the duty of faith, what these generally mean is that owners of a company have a responsibility to act in a reasonable manner that isn't going to intentionally harm or cause damage to the minority owners. So that's not the specific distinct definition, but that's the general landscape of what we're dealing with: loyalty, care, and good faith. So limits of fiduciary duties and discussions of waivers. Not all fiduciary duties are absolute. Agreements can limit certain duties provided that language is clear and enforceable. Courts will often uphold these waivers, but only if they're unambiguous and made knowingly. So this does get a little bit tricky because fiduciary obligations tend to be something that courts want to protect. And in New York especially, courts are focused on fairness when it comes to partnership disputes. So just sort of in general, waivers do matter, but courts will only uphold them if they're abundantly clear, if they're absolutely express, and if they're knowingly agreed to. Now here's what's more interesting. As I mentioned about New York courts are kind of focused more on fairness, right? But when we go to Delaware, and Delaware is really the jurisdictional alternative that I'll focus on today, Delaware tends to be a little bit more aggressive about enforcing contracts on their terms. So it actually would be possible to have an agreement, whether the bylaws or an operating agreement, One governed by New York law, where a waiver cannot actually waive a fiduciary duty. Yet when you're in Delaware, the opposite might be true. So if Delaware law governs one of these documents, a court in Delaware might interpret a waiver differently and say that's fine, you're allowed to waive that fiduciary duty. So when in doubt, if there's a concern that your statutory or your contractual language may not be clear enough, you probably want New York law to apply. When we're dealing with Delaware, the courts are more likely to focus on the specific language of the contracts in question. Statutory protections. So as I mentioned, each state provides different statutory protections for companies depending on their structure. And understanding these nuances is really key to effective counsel. Statutory rights, I would think of them as acting as a backstop. So ultimately, anytime we have members of an LLC or shareholders of a corporation, we always want to have an agreement that's governing how those individuals are interacting amongst one another and under the umbrella of the entity itself. But even if an agreement is silent, that's where state law comes in to provide certain rights, like inspections to books and records, rights to dissolution, or rights to an appraisal. So know your venue. New York is generally more protective than Delaware, but again, it's important that we understand the different acts and the different scope of what protections they do or do not afford. And just to kind of give you an example, in New York, both under the LLC law and the BCL, a member or shareholder has a right to inspect books and records of a company. Interestingly enough, though, if you're a member of an LLC and you make a demand for an inspection of books and records, even if your operating agreement doesn't speak to whether or not you're entitled to it, you absolutely are. You make the demands, it can be made through counsel, it can be made on your own. If they fail to provide it, you can proceed to litigation. Under the business corporation law, there is it's a little bit different. So you actually have to have a signed affidavit where you make the demand and you go through a whole process before you can file a lawsuit. Because if you don't, it's possible that on these procedural grounds, that if you didn't apply or interact with the statute the way you needed to, the court can ultimately dismiss the case. So understanding these nuances between the BCL and the LLC law, even just in New York, is vital. But also, even though you have statutory protections, these by no means serve as an alternative to having an operative document that governs the roles, responsibilities, and limitations of what the members or the shareholders can or cannot do. Inspection rights. Speaking of inspection rights, so access to books and records and proper purposes. Minority owners, no matter how minute, have an absolute right to inspect books and records of the company in which they are an owner of. These rights are not just formalities, they're essential tools to identify mismanagement or diversion of assets. And books and records, like we just said, aren't formalities. They're often the first source of evidence in a litigation. So denial of access is an early red flag and sometimes the trigger for a temporary restraining order or a preliminary injunction in order to preserve the status quo of a company. And so in these scenarios, what we often tend to see in our office is you'll have a minority owner of a company and they're not even certain of what the scope of their rights truly are. They make a request, they want to review the financials, maybe they'd like to see access to bank accounts or get a sense of what the P&L of the company looked like for the last quarter, maybe it's for the last year, maybe they're looking for access to tax returns or say, you know, I never actually received a K-1, but I'm entitled to that as a member of a company. In fact, I'm supposed to receive one, aren't I? So member goes to the managing members of the company and the minority says, hey, I'd like to inspect, I'd like to take a look. They're locked out. Now, maybe it's simply a response that says, you know what, we're not going to provide anything to you. Maybe they receive silence, or maybe they start seeing some sort of retaliatory process where they become locked out of the business altogether. There's a whole litany of ways that a request can be made for the inspection of books and records and what it is one is seeking. Ultimately, the itemized documents sought need to be reasonable in nature and scope, but if you have a majority or the majority members are locking out a minority member from inspecting books and records or taking additional measures, that might be a time where court intervention becomes necessary. And once again, you can certainly file a petition to inspect books and records in the New York court system, or alternatively, if the activities are considered to be nefarious, or if there's retaliatory conduct and there's a concern that monies are being diverted, or perhaps there's intentional fraud where a managing member that has bank account access, there's a belief and there's a causal reason to believe it that the funds have been improperly withdrawn, whether for self-gain or to another business entity, then one can run into court and file for a temporary restraining order. It's an order to show cause to seek a temporary restraining order and enjoin that participant from continuing that nefarious conduct. Also, as part of a TRO, you'll also seek a preliminary injunction, which basically would be an attempt by the minority owners to enforce a court order that will stop the majority member from doing what they're doing pending the outcome of the litigation. And the reason why that's important, and for those of you that have heard me speak before, I tend to talk a lot about injunctions. The reason why that becomes important is because courts always want to maintain the status quo of the entity or the company pending the outcome of litigation. And if there's a concern that one party is depleting and destroying the business, whether it's a multitude of defendants or just one, then the court will say the last thing that we want is irreparable harm to take place, which would ultimately render a judgment at trial worthless. So in other words, if party A as a minority runs into court and says, I was denied access to books and records, and then after that I did somehow obtain notices that the funds were being depleted out of the company, and we can show that through some level of proof, a judge is likely going to say that I'm going to enjoin these majority members from doing this, or I'm going to attach a bank account and basically freeze it. So that way, minority owner, if we get you to the point that you ultimately are successful on the merits of the case, at least there's still a company there to operate, right? So that's something that's very important. It's something that we tend to see a lot when we're dealing with oppression claims. So even though oppression claims are direct, can revolve around just causes of action by filing a summons and complaint, that equitable relief is often something that's also, it might be ancillary, but it tends to be part of these proceedings as well. Voting rights. So it's important in agreements, especially when dealing with minorities, that we want the minority owners to have certain protections. So supermajority or unanimous votes, vote requirements, are ways to ensure that a minority owner still has a say in the ultimate outcome of what happens. Now, for those of you that practice in this space, I think one thing that we could say is sort of typical, and there are statutory accompaniments to this, is that if you're seeking dissolution of the company, usually you need some sort of unanimous consent. It matters not if the 75% majority owners which dissolve, that 25% minority owner can actually stop that. Also sales of the company itself. If a minority owner is against the sale, but a majority tends to approve it, well, maybe we're not going to allow that. Now, some agreements or operating agreements or bylaws and shareholder agreements will indicate that a supermajority is enough. So we only need to get to a certain threshold beyond just a majority, but we only need a certain threshold before authorizing the sale of a business. Those situations can be contractually agreed to and often are enforced. But ultimately, minority owners, based on the written language of their agreements, can leverage these types of provisions, and therefore they actually will have influence over critical decisions of the company. And so, supermajority requirements are built-in protections, and if they're structured well, they'll give minority owners a seat at the table for existential decisions, and those can include mergers, asset sales, or amendments. Now, I will say that those types of provisions may seem innocuous early on from the majority side. They may not seem like a big deal from the minority side, especially if a minority shareholder is trying to make an investment. They just want to get into the company. But especially when sales get involved, especially when mergers are happening, or if the company is looking to deviate into a completely new area of business, if an agreement structured properly, the minority owner who went from basically having no say in anything suddenly is one of the biggest poker chips in the entirety of the company. So this becomes strategic. There's sort of a game of Monopoly that gets to be played, or I should say a game of chess that gets to be played, where the minority owner now becomes an important component that can actually withhold a sale in its entirety. And in fact, we recently just had a matter involving this very topic where the minority owner simply refused to sell. And by refusing to sell, what wound up happening was the minority owner was able to negotiate a very favorable buyout that was probably above the market value of their shares. But they were able to do it because the minority just wanted to get the sale done and through, and they recognized that this minority owner had the feasibility and possibility to completely withhold and hold up the entire process itself. So provisions and agreements, again, they may seem innocuous early on, but there's a lot that can happen in both strategically and outcome-based when you have certain provisions that give minority owners the ability to stop, stymie, or limit a certain function of the business. Information asymmetry. So majority owners often control what information is shared. Minority owners must assert their rights to avoid being blindsided. Generally speaking, the majority will control the information flow, and the minority, in asserting their rights, needs to take an affirmative step to indicate that they do want to gain access to certain books and records of the business. So just thinking about this in general, control of information is control of power. And this asymmetry is the breeding ground for oppression. Where many minority owners don't realize they're losing ground is in that idea that they don't actually have control over the information of the company. Early on, it may not seem like a big deal. Maybe they're getting monthly status reports. Maybe they are receiving some quarterly reports. But usually, books and records access turns out to be the basis for where minority shareholder oppression claims start to come into play. Okay, cumulative remedies. As previously mentioned, there are multiple means and avenues to explore when we are seeking to enforce rights of a minority owner of a company. And some of those are fiduciary based, such as claims arising out of a breach of fiduciary duty. A minority shareholder oppression claim itself arises out of a fiduciary breach. And of course, keep in mind that it's very rare for one to file an action only asserting a minority shareholder oppression claim. Usually from the common law perspective, we're focused on breaches of fiduciary duties. You'll see the oppression claim. You might see a claim for unjust enrichment. If monies or assets were converted, you'll see a claim for conversion. It's not unusual to see an accompanying claim for fraud, so long as you can establish intent and the signed term necessary to validate your claims, and a litany of other claims depending on the type of factual background that's taken place. So a tortious interference of contract claim may be raised. Corporate waste and mismanagement may be raised. We never know, but it really depends on the facts of the matter. So those remedies start with the common law claims. They shift over to statutory claims. If you're making a petition for dissolution because the relationship is broken down beyond the point of repair and it's no longer practicable for the parties to operate together, that's a statutory claim that can be alleged. And then, of course, we have the contractual protections that one can file a lawsuit over. So while we're talking about a breach of contract, we would look to the specific provisions of the contract itself. And oftentimes we do get very valuable add-ons to the common law claims and to the statutory claims. And just, by way of example, you could certainly have a scenario where you have majority members who decide that they have so much power and control over this company that they're going to set up a different company and use the trade secrets of Company A, the one that they're majority members of, and they're going to use that to incorporate that into Majority B. Or maybe they're going to take a piece of the business involved in Company A, they're going to actually shift that over to a new entity they create, and they want to leave out and block out the minority owners. Now, this might sound like it's kind of off kilter if you're not involved in the world of litigation, but assuming that most of you are, then this probably doesn't sound so unusual to you. And in those situations, after a review of the contract, you might see that there are very clear provisions that protect confidential information of the company, that protect company trade secrets, and make clear that they can only be used for the sole purpose of advancing the business itself. Or they can only be used and cannot be shared with third-party entities or individuals, which by its very nature is setting up a new entity that would be considered a third-party entity. Of course, there are a lot of other circumstances and situations. Usually in a contract or an operating agreement, you might see non-compete language. So the majority owners have a responsibility, and potentially the minority owners, but not to compete with the ultimate business that they're operating. So if they do set up a competing entity in one form or another, that might be another contractual provision that is violated. And then, of course, it can get a little more complex and complicated, but there might be certain provisions that relate to liquidated damages. If a majority member performs an act or does something that's improper, the minority may be able to invoke that liquidated damages clause. There is no limitation on the types of breaches of contract that one can allege, so long as there's a contractual arrangement amongst the parties and the minority shareholders' rights have unequivocally been violated. Okay, so we're going to talk through some practice tips here. We'll discuss early red flags. We'll talk about some exclusions. We'll go into some unexplained financials, and then one-sided amendments. So just generally, when a client shows up with incomplete financials or tells you that they're being left out of decisions, it's often the tip of the iceberg. So these are not just operational quirks. They're signals, and they're usually strong signals of underlying conflict. So, just think about this way. A client comes to your office and says, I have been a 12.5% owner of this company for the last 7 years. Every single quarter, I received a certain amount of a distribution, and the distribution was based upon the earnings of the company. I used to be given profit and loss statements at these times and would always receive K1s. And then over the last couple of years, though, I noticed that, number one, I still received those distributions quarterly, but they started to shrink. And when I asked questions about why that might be the case, I was given evasive answers. And then I noticed that the P&Ls that I previously used to get were no longer actively given to me. I went out of my way, though, to start requesting them, and I did get documents, but I'm noticing some inconsistencies when I look through things. For example, I know for a fact that the size of the business hasn't changed, and yet somehow the liabilities of the company with respect to payroll has gone up significantly. Also, I noticed that it seems that we've hired no new marketing vendors, and yet there's a bill going out, or there's an expense on the P&L that shows that a vendor is receiving $25,000 a month. I've never heard of this vendor. It was never announced at any of the meetings of the business, and I'm very confused. These aren't just to a prospective client. They might be coming in thinking that, well, I'm a little concerned. I'm not sure what's going on, but as legal practitioners, we know there's red flags abound. And not only do we potentially have an issue where our minority is not receiving his or her fair share, but it could actually be the case that the company is consistently being fleeced, and there might be significant self-dealing that's going on. Now, in terms of exclusion, which we sort of reference to an extent, is obviously also a very big problem. Exclusion can happen in a way that appears more innocuous, perhaps in the situation I just referenced, especially for a minority owner that's not overly invested and involved in the day-to-day of the company, or it could be readily apparent. Perhaps a minority owner was accustomed to gaining access to all of the managing members of the company or the members of the business. Perhaps they were involved in high-level business meetings, and now suddenly they're shut out. Now they say, well, we had a difference of opinion, but I have no reason to suspect that anything else is changing. That might be the actual pivotal moment in time where everything's changing, where the funds are being removed from the business, where decisions are being made to the detriment of the minority owner, where they're trying to go behind the minority owner's back and come up with a way to amend the operating agreement to dilute that minority owner's ownership interest to a point that renders their value in their company essentially worthless. These are always highly problematic situations where even if the minority owners don't initially see it as a major flag, we know that this can be a high alert problem and we need to take action immediately. Similarly speaking, unexplained financials, as referenced, if we're looking at financials and P&Ls and we're looking at tax returns and things just don't seem to make sense, it's at that time where it's imperative that we find out why, and not just sort of take a back seat and say, well, maybe this happened, or let's assume that we didn't know about this new employee hire, or we didn't know that third-party vendors were now hired. Or if we happen to notice that there's withdrawals from the bank accounts that simply are unexplained and they look like they're cash distributions, remember, a minority owner may not know that they're entitled to equal distributions across the board. So if the 75% take a distribution aligned with their ownership interest, the 25% is entitled to their proportionate share. But if they're not getting that, they might not know that they're entitled to their proportionate share. It's incumbent upon us as counsel to take a look into what's taking place, recognize the issue, and then take affirmative actions to protect the client. And then one-sided amendments. Of course, if a minority owner says what I just mentioned, well, there was an amendment that was initiated and it basically limited my interest, and they've diluted me or they've limited me even more. I didn't know that that was a violation of the operating agreement or potentially statutory authority or common law based upon the details. That's something to take up right away and to look into, and probably warrants at the very least a demand letter being sent, but certainly that could warrant immediate action in court to ensure that the minority's owner's rights are protected. So these are kind of always things, these are flags to consider at the beginning when you're speaking with somebody. Of course, it's always imperative that you review the operative documents that are governing the relationship between the minority owners and the majority. And I would also strongly urge you to ensure that your client brings with you the signed copy of the agreements. Oftentimes, we have discovered that clients will provide an unsigned copy and insist that it's the only one that exists, only to find out later that it turns out there was a signed copy. And even though the nuances and changes are small, those small changes actually can have wildly large ramifications for the business. So things to be wary of, things to be mindful of. Okay, so really now honing in on minority oppression. So what is minority oppression? So minority oppression is more than just unfairness. It's conduct that thwarts the minority's reasonable expectations, especially around profit, around participation, and around purpose. It's often subtle, tends to be cumulative, and intentional. So the legal standard for minority shareholder oppression under New York law is set out in the BCA section 1104 for corporations. And it allows a minority shareholder to petition for judicial dissolution if the controlling shareholders engage in conduct that is considered to be oppressive, that is considered to be fraudulent, or that is considered to be wasteful. Courts will focus heavily on whether the conduct frustrated the minority's reasonable expectations when they became an owner, like expecting to participate in management or receive fair distributions. And I can't express enough that the frustration of the expectations or the purpose is sort of that focal point that the courts will look to determine whether or not there's been oppression. With respect to LLCs, there's no specific oppression statute, but courts apply a similar equitable principle under New York LLC law, section 702. A minority member can seek dissolution if it's not reasonably practical to carry on the business in accordance with the operating agreement, and that will often be due to allegations of exclusion, to mismanagement, or abuse of control. So in both settings, the standard isn't a rigid checklist. It's about fairness, it's about equity, and whether the majority is abusing their power to the point that they're trying to squeeze out or economically starve the minority owner. And I think that's a really key important point when you're dealing with oppression, because a lot of other claims, for example, a fraud claim, is very clearly intentional with respect to its elements. An intentional statement of fact, right? An intentional misrepresentation that is relied on to the plaintiff's detriment. And as a result of that reliance, which, by the way, needs to be shown that it was reasonable, they suffered damages and have suffered harm. And of course, that plaintiff has to reasonably rely on whatever the statements made by the defendant are, and the defendant has to know they're false when they're making those claims. So there's sort of this very clear structured path when we're dealing with elements arising out of fraud. But when we're dealing with oppression, we're really focusing on that frustration of expectations, frustration of purpose, and whether or not what's happening could reasonably be considered to be fair under the circumstances. So that's where the subtleties come in with that minority oppression claim. Okay, so common tactics, squeeze outs, freeze outs, dilutions, these are all patterns that are crucial for timely intervention. So when we notice that a minority is essentially being shut out or locked out of the company business, and that could be they're physically being locked out of the premises, they are denied access, they're trying to get their security and suddenly their security cards aren't working, sounds like they're being locked out of the company. If we're dealing with other scenarios where suddenly their work emails are no longer working, or they used to have access to the back end of the company websites, or they used to have viewing access to the company bank accounts, those are all highly problematic. Maybe we're dealing with a different situation where we're dealing with dilution. And again, I mentioned dilution earlier, but often we see the majority will come up with passing some sort of resolution. Maybe they just need a majority vote to introduce an amendment to the operating agreements. And so they do so, but they really do so in bad faith with the sole goal to dilute the minority member even more. Again, if a minority member makes a complaint or references something with respect to something they want to see or they feel they're entitled to be a part of, the majority can't just then take oppressive actions in response and then rely upon contractual language that says that the majority can essentially render any determination that they deem that they want to. There are protections that tend to come out of this minority oppression claim where that fairness is going to be taken into consideration. Withholding of distributions. So withholding of distributions, of course, is problematic. And to be clear, these slides are about financial and operational control. So when we're dealing with these situations, it's important to ask yourself, are decisions being made to grow the company or to suppress another owner's economic rights? And so withholding distributions, there's a number of different ways that this can take place. Of course, there's the very clear way that's a violation of statutory and common law, where you have just one member of a company receives a large distribution, the minority owner receives a small distribution, and it's not proportionate to their equity ownership, the majority is just taking. And maybe they choose to keep taking and taking and taking without regard for the minority owner. That's highly problematic, and it's very clear that there's a violation of the law. But often what we see when we're dealing with these LLCs with minority members or with corporations is that they'll go about these things in a different way. And what they'll do is, in these privately held companies, is that the majority may decide to double or triple their salary for no justifiable purpose. Maybe they'll even quadruple it. And what they'll do is they'll say, well, now there's really nothing to distribute because our net profits, as they're showing on our profit and loss statement, are nominal. Whereas the reality is that the majority could have had distributions that would go to the minority and the majority, but they wanted to avoid that. They embarked upon this intentional campaign. And in order to put the minority owner in a very bad position, they increased their salary substantially. So that's something that we see often. It's something that usually tries to be done subtly, but it would also justify a cause of action in violation of the law. So that's not something that is to be considered lightly. It's a it's a highly problematic issue in these types of situations. Retained earnings, the portion of a company's net income that is not distributed to shareholders as dividends or distributions, but instead is kept within the business for reinvestments or reserves. Now, generally speaking, majority owners can retain profits excessively to avoid paying distributions to minority owners. We do see that, and it's always legal to retain earnings, but if it's done disproportionately or strategically to harm the minority owner, that's when the oppression claim can be initiated. So retained profits are the earnings a company holds back instead of distributing to owners. It's not inherently improper, but when the majority retains profits to avoid paying the minority while simultaneously paying themselves high salaries or making insider transactions, that's when we start to cross the line into oppression. So something to be mindful of, something that we always want to focus on, and something that needs to be discussed with your clients if they come into your office, and when you're reviewing P&Ls or they have their CPA talk to you, you start to see that we're dealing with these withholdings and distributions in a problematic way. Okay, exclusion from management. So focusing on exclusion of management is certainly something that we see often. And in this scenario, this constitutes a member, a minority owner that previously was involved, whether involved in voting, involved in decision making, might have been day-to-day decision making, and might have been having a seat at the table when larger votes were cast. But regardless, maybe they've been completely excluded from management. And that's something that we see often, where suddenly the C-suite says, we don't want this minority owner involved at all, and we are going to preclude their ability to even participate on a day-to-day basis, to be involved in the know-all of the company. And by the way, it can also happen in a scenario where a minority owner actually was heavily involved with establishing the business. Maybe they made an initial investment. It was always known they'd be a minority because they weren't going to be working 9 to 5 or working full hours for the company, but they were strategically and at a high level involved. We can certainly run into these situations and scenarios where suddenly they no longer are involved. There's been a lockout and they're being denied participation. That might be a justification for a minority shareholder oppression claim. And then documenting such exclusions will strengthen claims. So it's always important when dealing with these minority owners to ensure that they write down and have appropriate metadata where they can say, on this date, this is what happened. On this date, this is what happened. Again, when we think of minority oppression, it's not always completely overt. Sometimes it's something that happens over time. So imagine a dual scenario of I'm being denied decision-making authority. I don't even have a seat at the table anymore. It could be more straightforward where there was a vote by the company, and even though I'm a minority, I have a right to vote, and they ignore me altogether. But maybe it's not, right? Maybe it is. Well, they're just no longer inviting me to meetings. And then I noticed that all these majority members of the LLC have tripled their salaries, and now there's no distributions. Or maybe they only doubled their salaries, but they doubled their salaries or gave themselves a raise of some sort, and they're also locking me out and not allowing me to participate. And on top of that, I'm starting to notice that our company direction is changing, and they're having conversations with possibly trying to bring in new people. And they just advised me that they plan to amend the operating agreement, but they're leaving me in the dark otherwise. These are sort of the things to look for when we're trying to decide whether or not we have a viable minority shareholder oppression claim. So it's always important to be very, very descriptive when you're asking questions of a prospective client. You'll really want to dig into all aspects of the company. You'll want to know and understand how the company tends to operate in general, or how it operated previously prior to when the problems began. You'll want to know what the minority owner had access to from a records perspective, from a document perspective, from a people perspective. You will want to have an understanding of their overall influence on the company. And then you'll want to document the changes, when things changed, how they changed, with whom they changed, and how it's actually impacted this prospective client of yours or this minority owner from their day-to-day participation in the company, from a financial perspective, from a voting perspective, from a communication perspective, and from an access perspective. So these things they all sound like they're sort of obvious when, after the fact, you see that there's sort of this just, terrible scenario that was presented. But in actuality, on a day-to-day basis, sometimes it's not so easy to really confirm that there's enough there for an oppression claim. Burden of proof. So it's imperative in an oppression claim that there is a showing of unfair treatment. As previously mentioned, unfair treatment, and again, the showing that there is a major underlying fairness issue is really where the focus structure needs to be. And through this lens, it's always important that the minority owner shows that they actually have suffered some sort of oppression. And how do we do that? Well, we will look to witness testimony. We will look to financial records. We will look to emails. We will look to meeting minutes. We'll look to testimony of others. So everything that I just mentioned is going to be highly important. And a big thing with these oppression claims is that they're very factual in nature, right? So that's why if a minority owner tells us that, well, I'm a minority owner of a business. Let's just say it's, member A is the majority owner and member B is the minority owner. And maybe member A is the majority owner and member B, though, operates one office and member A operates, let's say, the main office. So member B is, let's say these happen to be physicians. Member A is working out of Manhattan. And member B is a minority owner in both Manhattan and the Long Island location, but member B operates the Long Island location. So now you have a situation where member A decides that they get into some sort of dispute with member B, and now all of the patients that were going to members B's location are told that, oh, members B location, where member B gets more financial allocations than member A, that location is actually closed. So come on into member A's location, where member A gets a higher percentage of all the revenues coming in. That's a problem, isn't it? But we need to prove that. So that's where dialogues and conversations are going to be had with people that are answering the phones, with witnesses from member B's satellite office who can speak to what they know or what they heard from the patients. Maybe certain patients wind up calling in saying, I'm just calling to confirm, but I received notification that this office is actually closed. Well, an affidavit from the receptionist who can speak to these dialogues and conversations are going to be important. Maybe even more egregiously, with member A knowing that they will receive more revenue from all the shared patients that come into Office A, they decide to lock member B out of the medical record system for the satellite office on Long Island. Member B, the physician, can no longer even work with his patients because he doesn't have access to their charts. He cannot access their prior histories, and he's not able to treat them at all. Certainly, this sounds like this would be considered pretty oppressive in nature, and so if there were to be some sort of initiation of suit, an oppression claim along with other claims would be initiated, obviously fiduciary breaches, potentially fraud claims, claims for unjust enrichment, because these monies are now going to member A, given that they have more of a majority stake in the financials when patients come to company A, and this could all be part of not only a possible filing, including a minority shareholder oppression claim, but potentially a TRO and a preliminary injunction will be sought to stop physician A from locking member B or physician B out of the company, the medical record systems, and stopping and enjoining member A from diverting patients away from satellite office B. So this might sound like it's a foreign scenario that would never happen, but I assure you these things do happen in practice. Okay, so whenever we're dealing with litigation strategy, now if you're a general counsel for a company, obviously these are things that you're going to want to basically make your members aware of, but at the same time, if you're representing someone prior to litigation, the strategy tends to involve how we can protect ourselves. And the first thing that an attorney is going to do is they're going to review the operative agreements of the company. They're going to see what rights are available. They'll also, of course, just freshen up on the statutory authority, and they'll know what common law rights a minority owner has. But regardless, one thing that they will always do is they're going to be telling the minority owner to document these incidences, to make sure that anything that seems suspect, whether it regards financials, whether it regards employment or salary raises, whether it involves the day-to-day of the company, whether it involves meetings or access or anything that seems unusual, write it down, save it in real time so that there's metadata that will show that this was taking place at all times. If it seems that there's been a point reached where the minority owner essentially wants a buyout, they want to leave, then that's when a negotiation can begin concerning a potential buyout from the company. So this is something that's certainly important. It's something that certainly a minority owner is going to want to be aware of their rights, and their rights can come in multiple forms. But if there's a well-crafted operating agreement, there could very well be buyout provisions, which we'll talk about a little bit later, but that will involve the means by which a minority owner can actually achieve a buyout. And sometimes, by the way, a minority owner can have the right to a buyout if they elect to do so in the proper manner. Sometimes they have a right to sell to a third party, subject to the right of first refusal from the majority owner. So in that instance, a minority owner might be able to obtain a fair market value valuation of their equity interest. They can find a bona fide buyer for value. They then have the opportunity to present that offer to the majority owners. The majority owners then have the right to decide whether or not they wish to buy out the minority owner at that fair market value rate, or if they choose to let the minority owner walk, in which case a new owner will come in. Oftentimes in those situations, there are protections in operative documents where there's clarity revolving around what a new owner's rights may be in the company. And even if a minority owner, for example, was involved in the day-to-day business of a company, even if they had voting rights, which might have been limited to their equity ownership or might have exceeded that, a lot of times in those situations, there's carve-outs that explain that if a new minority owner comes in, they'll be considered to be a silent partner, meaning they will have no voting rights, they will have no right to operate the business on a day-to-day basis. So, as I'm talking through these things, I'm giving you kind of general examples of things that we see in operative documents, but this is something to be mindful of when you're reviewing an operating agreement and advising a prospective client or your current client about how they may be able to negotiate or leverage their operating agreement in order to secure some sort of favorable outcome. And then, of course, based upon a review of your operating agreements or your shareholder agreements and bylaws, you're going to want to determine what remedies truly are available. You may have statutory authority to obtain inspection of books and records, but your operating agreement might expand that. You might not only have the right to inspect books and records, but if there's a refusal to provide them, maybe you can recover your attorney's fees for needing to initiate an action in the first place for that recovery. And it's not uncommon to see fee-shifting clauses in operative documents that make clear that if one of the members needs to initiate a suit against one of the other members to enforce a right, the successful party is entitled to a collection of their attorney's fees. Other strategic decisions might be what the agreement calls for. Excuse me. So does the agreement actually call for litigation in the event of a dispute? Is there an arbitration clause, which the minority owner will need to take into consideration, because now we're not just dealing with expending fees on an attorney, but there's likely going to be shared costs for an arbitrator or a panel of 3 arbitrators, and costs that will go to the arbitral bodies such as the AAA or JAMS. And in those situations, your fee assessment is going to be a lot higher. Now, the corollary or the opposite of that is that the managing members too are also going to have to pay those additional fees. But knowing whether your forum would be litigation or whether it would be arbitration is really important, and it's essential to determine an appropriate analysis of how you want to leverage the position that you are in. Another option may be that there's a mediation provision or a mandatory mediation prior to arbitration provision. And in those situations and circumstances, it's not unusual that one of the parties can seek judicial intervention, but before they do, they have to make a good faith effort to mediate claims. Now, these mandatory mediation provisions can be very useful, because if you are able to resolve what otherwise would be a 1 to 3 year litigation with expansive costs simply by going to mediation, it'll be a big financial save. It allows the parties to move on much sooner. Each party can obtain peace of mind, and a minority owner can either move on or ensure that their rights are supported without actually having to go through the entire court process. However, if it turns out that mediation is unsuccessful, then even though it's fair to say that an unsuccessful mediation is still successful because it gives the parties an idea through communications with the mediator of how things will wind up if this matter were to be litigated, the reality is the minority owner has just spent a significant amount of time, effort, and resources on a process that ultimately didn't work out. However, The reality is that we never know exactly how a mediation or a litigation is going to play out. While attorneys can advise and can give sort of ideas of how things may play out, there's always going to be an unknown as part of any element, whether you're in mediation, whether you're in arbitration, or whether you are in litigation. Valuation disputes and why they arise. So valuations are where oppression becomes quantifiable. So fair value protects minority stakes, and fair market value includes discounts. The difference can be hundreds of thousands or more, and we'll go into that. So why valuation disputes arise? Number one is that valuation disputes tend to be triggered by forced exits. They tend to get involved when we're dealing with a buyout or when we're dealing with dissolution. So these stakes tend to be high. These are high stakes situations. Hundreds of thousands or even millions of dollars in disputes can be on the line. And so when we're talking about valuations, that's when we know that things are getting, for lack of a better way to say it, things are getting real. And sometimes we'll see valuations in processes where we're simply trying to negotiate with the opposing party. So therefore, we're in a situation through counsel where we're going to get a third-party valuator to determine the valuations of the parties so that the minority owner can get a buyout. And sometimes that buyout's coming because the minority owner is threatening to sue the majority owner because of oppression, because they've been locked out, because they lack access to financials. And they basically are saying, pony up, show us the financials, or in the alternative, we'll take a buyout now, but it's got to be based upon a fair market value. Other times we perform valuations through mediation, and the mediator will be given a mediation statement, but also will be a shared valuation will be provided to the mediator so that they ultimately have a sense of where the company's valued so that they can assist with getting the parties to a reasonable buyout. And then when we're dealing with a dissolution, it's always imperative that there's a valuation because dissolution means that the company's assets are going to essentially leave the company. And how do we value each member's interest and stake? That's done through a valuation. Now, valuation provisions can also be anything from very simple to complex. Sometimes operative documents don't talk about them at all. Sometimes they talk about them excessively. Imagine the situation where we have one valuation. And perhaps there's a good negotiation going back and forth between the minority owner that's threatened the majority, but the majority says they'll play ball and we're going to get a valuation. Now that valuation may come out and let's say the majority owner, even though this was supposed to be a neutral valuator, somehow this valuation is more beneficial to the majority owner than the minority thinks is fair. Well, what are we to do? There are mechanisms to allow for more fairness. I've seen situations where each party ultimately gets their own valuator to render a valuation, and then when you go to mediation, each valuation is taken into consideration. I've also seen scenarios where there are valuations performed on each side, and then there's a third-party valuator that determines and renders a valuation that is going to be binding based upon the two separate valuations provided by the individual valuators. So how we get to these conclusions, how we structure these clauses, it may seem innocuous, but when they actually come into play, the outcomes can ultimately vary significantly. And now focusing on fair value versus fair market value. So amazingly, the difference between fair value and fair market value can guide your negotiation, can guide your full negotiation or litigation strategy. So fair market value tends to deal with the willing buyer, which we'll talk about. Fair value excludes the minority discount. So what do we mean by that? Well, under New York law, fair value is typically the standard used in judicial dissolution and shareholder buyout contexts, and that comes from the BCL section 1118. It aims to reflect a minority owner's proportionate interest in the business without applying minority discounts for lack of control or lack of marketability. So it's designed to be equitable, especially when the minority didn't choose to exit. In contrast, fair market value assumes a hypothetical willing buyer and seller in an open market and does include discounts that reflect the limitations of a minority position. So that difference, no discounts under fair value versus significant reductions under fair market value, can actually translate into massive differences in outcome. The choice of standard is often dictated by statute, but if left to contract, it must be drafted with clarity and intention. So imagine these situations, which becomes really, really interesting. You can be in a scenario where you as a minority owner have a fair value clause in your operating agreement. Now, if that's the case, that valuation is going to strictly consider the financials and the P&Ls and the balance sheets and all those fun things and the returns to ultimately determine what that fair value of your equity ownership is. But now let's assume fair market value. One word, changing so much. A prospective buyer under a fair market value situation likely has limited rights. And as we discussed earlier, those limitation of rights might mean that they're not allowed to vote, that they're not allowed to participate in the day-to-day functionality of the underlying company. There's going to be a discount that ultimately gets applied in the fair market value situation. So it's always really important to take this into consideration, especially as drafters, when we're drafters of documents. It's important to notice and recognize the differences. And when we are litigators or those involved in negotiating on behalf of our clients, we are going to want to advise the clients of the difference between this language and then be able to put our client in the best position to get the best possible outcome based upon the language that is being used. So valuations might seem like they're standard or part of the course or just sort of something that just happens, but we cannot express enough how important it is to have a very good valuator, number one, but then also to actually understand the scope of language that is being input into the documents that are governing the rights of the LLC, if it's an operating agreements, or that are governing the rights of a corporation, if it's dealing with bylaws, or if you're dealing with just a partnership agreement, dealing with partners where you have two or more individuals that are operating in business together for profit. So never something to be taken with jest, always something to take very seriously. And valuations tend to become the focal point of any type of resolution because let's face it, the monetary component and the financial number is ultimately 9 times out of 10 going to be the main purpose of what a minority owner certainly is seeking as part of a buyout. Sometimes it does involve IP, sometimes it does involve other rights or some sort of licensing agreement that gets sort of built into a buyout, but 9 times out of 10, that monetary valuation is going to be highly, highly important.
So we will now move on through our trajectory and process dealing with minority shareholder oppression. So we were talking about valuations initially, and we are going to be moving on now to the next phase, which will focus on judicial trends, focus on appraisal rights, and really kind of further dive into issues associated with buyout. So I'm actually going to jump to the next slide here very quickly. Just generally speaking, when it comes to judicial trends, New York and Delaware, as referenced before, are slightly different. So New York is more focused on protection. Think of the idea of stare decisis and common law and that sort of evolution of we want to protect the minority owners. Delaware has a much firmer hand where they're really focused on saying whatever the contract says is what we are going to enforce. And the way this tends to play out is that the oppression claims in New York are likely to be more favorable to a minority owner, whereas if you're a majority owner that doesn't really want to have to deal with minority protections, then you're in a better position so long as you have very strict contractual provisions that limit the rights and obligations of the minority owner. And of course, we see this tend to fiduciary obligations that a majority owns to a minority. You're not going to get away with those clauses nearly as much in New York, but in Delaware, you likely can get away with a lot more. Now, interesting trends. Delaware has been a really hot topic of late, dealing with derivative suits and dealing with sort of everything going on with respect to corporate litigation. And of course, a number of larger businesses have opted to leave Delaware in favor of some other jurisdictions. And actually, we received a call about this and sort of, we were quoted, I believe it was in a Newsmax article, but asking us why, what is it that is sort of lending things to this direction of companies saying, I've had enough of Delaware. And the reason is, and this applies in a way to what we're talking about here, even though, as I just referenced, Delaware is very contractually oriented, over time, what's happened is that, especially in derivative claims, Delaware was known to protect management. And management was significantly favored. Management was put in a position where the idea was that so long as the managers are acting to a certain threshold level of propriety, a shareholder claims, those claims aren't really going to survive dismissals. But over time, that has now evolved. And what we're starting to see is that shareholder claims are having much more luck, and they are now moving forward in many more circumstances than previously was the case. So you have this interesting trend in Delaware where, even though they were formerly sort of the ironclad, hand-down contract governs, we're starting to see this shift into new territory where Delaware is becoming a little more shareholder favorable. Now, how that's going to play out in more of these privately held company disputes, I think that's something interesting that should be watched, because as the judges evolve and as new judges have been appointed, there is a possibility that they might actually shift more and more over time to the New York trend, which tends to be more favorable to protecting the minority interests. So something to look out for, something to be mindful of, and perhaps in a future CLE, something to focus on. And before we even leave, just Delaware, New York, just, as kind of a thought process behind this, remember that venue matters. So Delaware will say that freedom of contract is what governs. New York courts are more equity focused. And of course, that one choice may determine whether your client has leverage or whether there's no leverage at all. So certainly something to be mindful of. Okay, appraisal rights. Such rights provide an objective measure of value and can prevent a majority owner from forcing a lowball offer. Now, what we're really talking about here is dealing with court-appointed valuations. And if you're a minority owner, ultimately, if there is no agreement for how to value the business, and if there is no real contractual language for how to value the business, if you're able to obtain a court-appointed valuation, you're going to be putting yourself in a pretty strong position as a minority owner to know that that valuator is going to have to be fair, impartial, and reasonable when determining a valuation. Now, having to get to a point where there's a court-appointed valuator is not really ideal, in that ideally you have contractual provisions that ultimately dictate and provide the protections to the minority owner that we're looking for. But nevertheless, it's very important to keep in mind that if the court is to appoint a valuator, the benefit there is, once you get to that point in this process, is that you're going to get somebody that's more fair, that's more impartial, and will ultimately lead you to a more balanced outcome at the end of the day. So something to be very mindful of. Okay, so now moving along. And in this section, we're going to focus a little bit more on derivative actions. We'll reference injunctions, we'll talk dissolution, and then equitable relief. So with respect to our valuations and structuring buy-sells, it's imperative that if you're going to put this language into an operating agreement, there's a lot of clarity. Now, clarity can revolve around, as I mentioned earlier, determining, are we going to have one valuation from one valuator? Are we going to have two valuators? Each side in a dispute gets to choose their valuator. Or are we going to have three valuators where each side chooses their own, then there's a third-party valuator that's perhaps even chosen by the initial valuators that's considered to be fair and impartial, who's going to balance out the two valuations. Because when each side picks their own valuator, 9 times out of 10, the valuation somehow is going to come out more favorably for the party who chose the valuator in question. So understanding how we're going to go about choosing a valuator is a very important process. Moreover, valuation formulas. This is another means by which we can avoid the whole papering any kind of outcome that we want to accomplish. So if we want to avoid posturing from valuators and valuations that tend to focus on certain aspects and push down other aspects, As an example, one valuator may say, well, the industry standard in a marketing business is a 4x multiple on the valuation, and the valuation is X, so therefore multiply by 4x, and considering your equity ownership share, this is what the valuation should be. But another valuator might say that, well, wait a minute, this is a nascent company. This company's growing fast. Year over year, there's been 10x growth. So why would we limit the valuation to simple math that we already see based upon P&Ls up until now and a multiple? We need to take into consideration future growth, and we want to base that upon, the last 3 years' growth or the last 1 year's growth. As you can see, there's many ways to sort of manipulate a valuation, and so introducing a valuation formula into an operating agreement is a means of avoiding all of the posturing surrounding valuations in general. So when you're dealing with a provision that involves valuations, putting in specific formulas for how one is to determine their buyout value is going to be very important. Again, you can discuss fair market value versus fair value. You can make an agreement that you can decide on the multiple in the operating agreement itself. And you can essentially even outline the scope of documents that will be considered for performing the valuation itself. So there's no limitation on how you construct the provision, but of course, constructing these provisions mean that you are going to be limited to what that provision actually states, unless it's considered to be somehow unconscionable or beyond practical to enforce. But nevertheless, valuation formulas are very valuable and they save a lot of headache down the road. Similarly, buyout triggers. Buyout triggers can also run the gamut. You can have a buyout trigger for a minority member, an option when the company reaches certain financial thresholds. You can have buyout triggers for illicit conduct. There could be a forced buyout at market value with no multiple in the event that there's some illicit conduct that takes place, in the event that there's fraudulent conduct or some sort of bad faith act. So buyout triggers can wind up being extraordinarily valuable. They can also be used when you're dealing with potential deadlock. And that tends to happen more so where you have kind of a 50-50 scenario. But deadlock provisions that lead to buyouts can often also be very valuable to ensure that a company gets to essentially stay afloat without having to go through the whole process of litigation. And then, of course, notice periods. Usually, if a minority member, for example, has a buyout trigger or a right to be bought out, whether it's over a certain period of time, when the company reaches a certain size, when a certain number of members enter, generally there will be some sort of notice provision. Now, that notice provision can include a right of first refusal, where the minority member maybe can't force a buyout or write a letter enforcing a buyout by the majority members, but they can go and get an offer from a third party, and then they're required to give that notice to the majority members who have a certain set period of time to either buy out the minority member or to allow the new member to come in. And then arbitration is listed here, strictly because sometimes when you have disputes, over buyout triggers or valuation formulas, if there's not clarity in the way these provisions are going to work, it's not unusual to find us in a situation where arbitration or litigation becomes essential. Okay, moving along. So now we're entering into a new realm. This is where I thought we were before. Derivative actions, injunctions, dissolution, and equitable relief. So that's what we're going to cover over the course of these next few slides. So just as a general sort of filler here, derivative actions are filed on behalf of corporations, and there are certain specific standing requirements that are necessary. So derivative suits can address mismanagement, diversion of assets, or breaches of fiduciary duties. And just think of, these things, the derivative actions, the injunctions, et cetera, they're sharp tools. Derivative suits expose management. Injunctions ultimately protect assets and relationships. And think of dissolution as a nuclear option, but sometimes one that is necessary. When it comes to injunctive relief, particularly TROs and preliminary injunctions, those often are the fastest ways to stabilize a situation, whether it's freezing a disputed bank account or halting a rogue decision by a majority member. But specifically, focusing on derivative actions, These actions are brought by an individual shareholder or a member on behalf of the company itself. So it's not for personal harm or for personal gain, but for harm to the company, the entity itself. And in privately held businesses, they're often used when the majority has breached fiduciary duties, diverted assets, or otherwise damaged the company itself. The benefit then is that it allows a minority owner to hold majority actors accountable when the company's leadership refuses to ultimately take action. And this is distinct from direct claims, which target personal injury to the shareholder or the member, him or herself, like exclusion from distributions or voting rights. So think of derivative actions as enforcing the integrity of the business, especially when insiders are misusing it for personal gain. And this becomes a really important tool, right? You could even have scenarios where minority members are filing claims arising out of personal grievances, but also there's a derivative claim attached as well. And think of derivative actions as management decides to make a substantial business decision, which cannot possibly be considered to be sound in fact, and they make a major investment of millions upon millions of dollars, or they invest in a new company, or they acquire a business that ultimately leads to a complete eradication of the business's ability to operate. Now, the individual shareholders may have claims, but the company itself certainly has claims for these issues of mismanagement and diversion of assets. And that's when the business judgment rule tends to get into play. And that's when management, will be under scrutiny to determine whether or not their actions were reasonable under the circumstances. So Delaware, of course, is very popular for derivative actions. It's historically known for derivative actions. For the reasons I mentioned before, we're starting to see this sort of shift away from Delaware, but it doesn't mean that that will be consistent. Only time will tell. But for a minority owner, the shift actually is a good thing. And the shift actually seeks to hold management more accountable. And in a privately held company, we tend to be talking about manager-managed LLCs, member-managed LLCs, where the ownership is also the management, and therefore we want to find a means of holding them accountable for losses to individuals, but also on behalf of the company itself. So as previously referenced, direct claims are focused on direct personal harm to the individuals that are filing the actions, whereas derivative claims constitutes harm to the LLC or to the corporation. So choosing the correct framing affects procedure, it affects remedies, and even the statute of limitations, believe it or not, can be impacted. There's also certain notice requirements, which is beyond the scope of this CLE, that are required when dealing with derivative actions, when we seek to have management take action on behalf of the company in certain situations, and some of those things are necessary before we ultimately file these actions in the first place. But nevertheless, derivative claims are a very potent tool, and they can be utilized in conjunction with claims for personal damages that also include minority shareholder oppression. Injunctions. So injunctions are an extraordinarily potent tool. Ultimately, and by the way, we haven't really discussed receiverships, and that's not ultimately a part of this CLE, but those are potent tools as well, to threaten receivership or to have a receiver appointed to take over the day-to-day actions or the day-to-day operations of a business. A minority can potentially have the ability to do that in the right circumstances, which, by the way, if you're majority owners, the last thing you want is a third party coming in to take over the day-to-day operations of the company. But there's nuances in those scenarios. Anyway, focusing back on injunctions, injunctions involve temporary relief to prevent harm to the business. So injunctions can stop the majority from taking actions that would cause irreparable harm, like selling assets of the business, excluding the minority from management, or diverting profits. These are often an early step in dispute resolution while litigation is ongoing. And the reason why these are so potent is because ultimately when you have a typical filing, depending on the defendants, but oftentimes they're going to continue their illicit or improper conduct. And in these situations, if there's a belief that nothing's going to change, that's when a plaintiff can, in the interim, in the short term, a plaintiff files an order to show cause. They seek injunctive relief in a temporary restraining order. They get their papers before court, and they say, Your Honor, it's essential and imperative that you issue some sort of interim relief right now to ensure that ultimately at the end of the day that our company isn't rendered worthless by the time this litigation ends. And there's certain elements that one will need to prove, to show, and to justify in order for a court, or a judge rather, to issue a temporary restraining order or a preliminary injunction. And in those scenarios, when you run into court, you're going to have to show a judge that if the judge doesn't take action and issue some sort of order in your favor to stop the bad faith actors from doing something, there's going to be, number one, irreparable harm to the plaintiffs. So we need to show that the harm or the damage asserted, the claims asserted, are going to result in actions that are so egregious that we're not going to be able to recover from this. Completely destroying a company, fleecing assets away, these are highly problematic and likely would arise to irreparable harm, depending on the circumstances. You will also, though, need to showcase that you have a likelihood of success on the underlying claims that you're asserting. So since you're filing an order to show cause, you also have a summons and complaint that's been filed as well, or at the very least, a summons with notice. The summons with notice is a quick way to get into court when the emergency is so grave that you don't feel you have enough time to unpack the totality of the complaint. But you nevertheless need to show in your moving papers through a memorandum of law that there is a likelihood of success on the merits of your claims. Now, what is the likelihood of success? You don't need to show clear certainty that you're going to be successful at the end of the day, and we'll explain why in a moment. But you need to show a court that there is a likelihood that you will be successful on your underlying claims. And then there's an assessment of the balancing of equities. You need to show to the court and explain to a judge that in the event that you grant this relief, it's going to benefit the plaintiffs, in our instances, these minority owners, more so than it's going to be a detriment to the defendants. If it turns out that you can show this irreparable harm, but the reality is that the harm to the defendants is going to be even worse, then that pendulum swing suddenly shifts, and a court may decide to decline to sign your TRO and ultimately your injunction after oral argument. Now, here's the interesting part about this. As a plaintiff in these circumstances and situations, and we see this a lot with minority owners and oppression claims, when we move for the TROs, it's not unusual to get to the preliminary injunction oral argument. Once we get to that preliminary injunction oral argument, it is not unusual for a court to require that the minority owner post bond. Well, why is the minority owner being asked to post bond? The reason is because if it turns out, after this matter is fully litigated, that the defendant's rights were ultimately violated by the issuance of this TRO and preliminary injunction, then there needs to be some sort of availability for the defense to ultimately recover the damages that they received based upon the decision and order of the court. So if the court issues the injunction, they also want to have protections in place for the defense in case, even though it looks like there's irreparable harm in favor of the plaintiff and there's a likelihood of success on the merits, they still want the bond posted just in case so that the defense has some sort of remedy if it turns out that this order should never have been issued in the first place. So injunctions are very powerful tools. They are often utilized in scenarios that do involve minority shareholder oppression, and they're a potent tool that can be wielded in favor of your client. Judicial dissolution. Judicial dissolution is an extraordinary remedy. Similar in the extraordinariness, similar to an injunction, but when you're seeking, and by the way, we're not talking about voluntary dissolution here. We are talking about a petition for dissolution, which is an involuntary petition where one party runs into court and says that it is no longer practicable to operate this business. The relationship is broken down to the point that, Judge, Your Honor, there needs to be dissolution. So when the courts, they will consider dissolution, fairness and feasibility will be considered, but the relationship absolutely needs to be broken to the point that the parties cannot operate. And the courts are first going to work very hard to have the parties mediate their resolutions before ultimately proceeding with a full dissolution. So the courts will weigh fairness, they will weigh the ability to continue operations, and the impact on both minority and majority owners. Okay, equitable relief. So equitable relief, just some discussions about mandatory buyouts, profit adjustments. These are scenarios or opportunities that one has to find a means of obtaining an outcome that doesn't necessarily focus on depleting the business. So buyouts tend to be mandatory buyouts tend to be means of finding equitable relief, maybe profit adjustments to allocate for any potential wrongdoing. Focus on equitable relief when you're looking to obtain outcomes that allow the business to survive without a full depletion of the company itself. Okay, so now we'll get back to the dispute resolution, which we did go into a little bit earlier, but we'll discuss in a little more detail here. So arbitration and mediation. What we really want to focus on is which actual dispute resolution forum makes the most sense, and that will vary from company to company, and it also depends on who you're representing, a minority or a majority owner, and taking into consideration things of the like. So, of course, we discussed the benefits and detriments of Delaware versus New York. So certainly prior to even discussing a forum selection clause, we'll want to discuss a choice of law clause. If you're going to prepare an agreement, every agreement should contain a choice of law provision. Otherwise, we could wind up in some sticky scenarios where there's an argument over which state's laws should actually govern a dispute. Not so much an issue if the company is fully located in New York and the members are in New York. Could be an issue if you have multiple members in multiple different states and operations are also spread across multiple different jurisdictions as well. So always ensure that you have your choice of law forum, choice of law provision fully spelled out. You will want to focus on venue provisions as well. Venue seems like it might be the lesser of import in these situations, and arguably it is, but at the end of the day, if all the parties are in New York County and the company's in New York County, it's clear venue really belongs there. But sometimes you have different parties in different locations. You could have parties in Nassau County, you could have parties in Dutchess County, and questions will arise which actual location is the appropriate venue for the action. So we always recommend including venue clauses in your agreements as well. Furthermore, when we deal with arbitration and mediation, we also are now dealing with different alternative dispute resolution forums. So mediation often is put into operating agreements as a prerequisite to litigation or arbitration. Now, if you're looking to streamline resolutions, but also give yourself the highest possibility of resolution early, having a mandatory mediation followed by arbitration clause might be a really good idea. And then you could even select which arbitral body you'd like to govern the dispute. Again, it could be the AAA, it could be JAMS. You could even set forth and make clear that you want the commercial rules of the AAA to govern. If you're dealing with members that are in different countries, you might want to consider a more international arbitration clause. That can involve a arbitration that takes place in a neutral third-party country. Not as much an issue with privately held companies, but it certainly can be as they get larger in scope and as operations are more sophisticated. Sometimes having, especially if you have, for example, and recently had this, one party in Germany, the other party in the United States, arbitration before the London Court of International Arbitration was going to be the seat, because the idea was to have some sort of level of neutrality, sort of like the federal court versus state court and rendering decisions of where it's best to follow your suit. So focusing on your venue, focusing on your choice of law, focusing on your location, even for alternative dispute resolution, is actually very important and really needs to be fully spelled out. Now, for purposes of expediting outcome, the benefit of the mediation to arbitration clause is that it gives the parties an opportunity to resolve. If they can do it, they've saved significantly on fees. There was a relatively quick process to get to an outcome, and they move on. If they don't, then they're going to arbitration, where generally you can have a hearing much more quickly than you will get to trial in an ultimate litigation. So that's the benefit you get with an arbitration. 6 months to a year is not unusual for arbitration to have an ultimate outcome, whereas the court process could take anywhere from 1 to 3 years. Of course, the detriment, as mentioned before, is that in arbitration you are paying the arbitrators. So you'll also want to carve out specific details about what an arbitration clause looks like with respect to the makeup of the panel. Is this simply one arbitrator that's rendering decisions, or do we want a panel of 3 separate arbitrators who are going to be making a decision jointly together for the ultimate outcome? And there's plenty of considerations to go there beyond monetary. Maybe you have a concern that one arbitrator, it's very complex, and therefore we want multiple arbitrators to go over the issues before rendering their decisions. So deciding what the panel will look like, deciding where the arbitration is going to be seated, are just a couple of the nuanced approaches you'll want to take when piecing together a validly constructed arbitration clause. One other thing to look out in arbitration clauses, and this has come up in our litigations, is mandatory versus permissive arbitration language. So believe it or not, in New York, even if there's an arbitration clause, it's always feasible for an arbitration clause to be written in a very loose manner, which, even though arguably it still should give the parties the mandatory requirement for arbitration, it actually doesn't. And what does that look like? It could look like something where it states that the parties may agree to arbitrate, or the parties, or something that doesn't have conclusive, definitive language. So the best way to produce language in this setting or circumstance is to say that the parties shall consent, the parties shall proceed to arbitration. That shall language, that must language, I think shall is best, but will give the type of enforcement mechanism necessary to ensure that one party can't get out of the arbitration. And believe it or not, you will have parties that will try and avoid arbitration left and right, even if it's just a publicity stunt to ensure that a public filing is rendered prior to the defendant then compelling arbitration and getting the court order to do so. So a lot of strategy goes into carving out these arbitration clauses. A lot of strategy goes into deciding how they should be drafted in the first place. Do we want to have the opportunity? If you're a minority owner, maybe you don't want arbitration, not only because of the cost, but because you're a little suspect of the majority owners. And you know what? Maybe it would make sense that if there were ever to be a dispute, which we hope there never would be, but you have that opportunity to render a public filing. Maybe that's something you're interested in. Maybe it's not. Maybe it's the opposite. Okay, so litigation risks. With litigation, of course, we are risking costs. We are risking time. The proverbial time is money can come into play, but when we're involved in litigation, sometimes businesses become stagnant while litigation is ongoing. Time is lost, and ultimately the growth and the success of the business is stymied while we're dealing with litigation. Of course, litigation also becomes very expensive, and the parties wind up pouring a lot of resources into this process. Then, of course, with the public filing and litigation as referenced, there's reputational exposure. May not be a problem for you if you're a minority owner that want to ensure that the company's exposed for potential misdeeds, but actually it might be because that filing may still follow you around when you go for your next opportunity or your next investment. Do you necessarily want to be associated with not only filing an action, raising the question of whether or not you're litigious, but also based on the facts and circumstances, third parties may question, well, shouldn't you have known about this? Shouldn't you have understood this earlier? Shouldn't you have seen this coming? That may not be fair, legitimate, or even a justifiable position to take. But the point is that these are things that really need to be thought out. And if you're working with your clients and you're building these clauses into your operating agreements, into your bylaws, into the shareholder documents, partnership agreements, you want to walk them through the potential scenarios and outcomes. Find what their bigger pain points are, depending on what it is they do and how they go about doing it. Passive investors versus active investors. Sweat equity investors who are participating in the day-to-day. Different considerations, different financial positions, different outcomes that might make them as happy as they can possibly be when resolving a dispute. And the idea is that, of course, we're always focused on getting to that point that we are providing our clients with the requisite peace of mind that they are looking for. Minority protective provisions. So rights to consent and veto rights. And at this point, we want to focus on the rights to consent clauses and what they really are. So a right to consent clause is a veto right that ensures no one wakes up to find that their ownership interests fundamentally changed without a say. And what this does is it's a provision that protects the minority owner if there's an attempt by the majority to, let's say, dilute the minority owner's ownership interest in a company. So having certain veto rights are imperative to a minority owner who wants to protect themselves. It can also show up in the scenario about a sale or a merger. If the minority owner is in a position where they have that contractual right to object, they suddenly become a very powerful piece in the company's ultimate construction. So a very valuable tool, something to strongly consider, and something that if you're counsel preparing a document, certainly if you're representing the minority owners, veto rights are imperative. There's something that you want to put in there because the minority will obtain the protections they're looking for. And preemptive rights. Preemptive rights protect the integrity of a partner's investment. If you help build the business from day one, you deserve the chance to keep your seat at the table when new capital comes in. So having that ability to not be dissolved, having that ability to ensure that whatever it was you had rights to, including from an equity ownership interest, possibly including from a voting rights interest, including from a participation interest, being able to maintain that ownership and those rights, even if others are coming in, is really essential, and it's a major value add to a minority owner in a company. So these are things that often get overlooked, especially when you're dealing with smaller privately held operating agreements. They're not typically spelled out in the standard form documents, and oftentimes in a lot of operating agreements that are generally involved and often detail-oriented, they still are not included. So these are things we want to be mindful of. These are things that are imperative to ensuring that a minority owner avoids oppression and avoids the need to file some sort of oppression action in the first place, if they even have the opportunity to, depending on what rights are given to them in their contractual document. Okay, minority protective provisions, tag-along rights and drag-along rights. So protective provisions are very important. Tag-along rights prevent the awkward scenario where the majority cashes out and the minority is left holding the bag. They ensure fairness and exit opportunities. So I love this name because the tag-along right essentially means that if the majority is going to be selling the company, if the minority owner is even just a 5% owner, they actually will have the right to join and tag along and ensure that their interest is bought out as well. And it's really a valuable tool for a minority owner because it gives them flexibility. If they're open to remaining in a business while there's new management coming in, new equity ownership coming in, a completely new system and a process, then all the more to them. They can remain as that 5% owner. But the tag-along right, which can sometimes drive majority owners crazy, gives that minority owner an absolute unequivocal right to be a part of the buyout. So being able to be a part of the buyout is not something that, can be looked to without significant value. And if you're a minority owner, this is something that you'll want to negotiate into any contract. Now, to be fair, while we're talking about some of these ownership interests, the reality is that all majority owners aren't going to necessarily agree to all of these different rights and of the minorities. But if you can provide some concessions in exchange, oftentimes you'll be put in a better position overall where you will have more and more protections in your operative agreement. And then we have drag-along rights. So drag-along rights are about practicality. They reassure potential buyers that minority interests won't derail a legitimate deal, but they must be balanced carefully with tag-along and consent protections. So this is also really interesting, right? Because let's say there's a prospective buyer of the company, and now the minority owner has a 5% ownership interest. Let's presume no tag-along right, but there's a drag-along right. What that actually does is the opposite. It allows the majority to ensure that the minority owner is going to come along with the majority owner. They'll get bought out as well. The difference here being the minority owner has no say. And the reason there is more favorable to the majority owner because the majority owners are dealing with the acquirer. And if the acquirer says, hey, look, we valued your business at X amount and we want to buy it, and the majority owners want to go along with this process and they've done their due diligence. There's been due diligence already and we're getting close to the point that a transaction can actually proceed. Well, if they have concerns, the buyer, about a potential minority owner, for whatever reason. I mean, it could be because the minority owner is a big personality. It could be because the minority owner is a participant in the company. It could be for no specific reason at all, but ultimately, if that's going to hold up the deal, the majority owner now has the opportunity to enforce a drag-along right, which means that the minority owner is going to be leaving the business as well. So protective provision as a tag-along, I think that's your best bet when it comes to the minority having the most flexibility. Of course, a minority owner simply being able to reject the sale if there's a unanimous vote requirement is in and of itself very potent. But nevertheless, these add-ons, these additions, these additional clauses that can be protective, it's always important to piece them together and make sure that they're written in a way that provides clarity, provides authority, and makes exactly clear what the rights and responsibilities are. Okay, deadlock mechanisms. So in these types of scenarios, we're really talking about, we have scenarios where the parties can't proceed for whatever reason. So let's say we have a minority owner that is refusing to sell, but the majority wants to, and we don't have any of these tag-along or drag-along rights. They simply don't exist. What do we do? Well, deadlock mechanisms, although they tend to deal with 50-50 partnership ownership interests, can also deal with these situations and scenarios as well. And in these types of situations, you can have a minority owner that ultimately refuses to or doesn't want to be bought out. And what they can do is they can have some sort of trigger in place. Now, that buy-sell trigger can work very interestingly because you can set it up in a multitude of different ways. And this works better, especially when you have a minority owner, but there's a closer sort of balance. It might be a 60-40 or, 51-49, but really 60-40, 70-30. And the minority owner has the opportunity, as does the majority owner, to basically force an action from the other side. Majority wants to sell, minority doesn't. So, or let's make it a different situation. The majority wants to proceed on an acquisition that the minority disagrees with. Well, if they're at a deadlock, the majority can issue, or the minority can issue, a demand for a buyout. And sometimes as a majority owner, you might be open to that at some point, right? And say, you know what, fine, buy me out. At that point in time, the minority owner will have the opportunity to buy out the majority owner in a certain amount of days and become the majority owner of the business, or they can do the opposite and basically demand that the majority owner buy out the minority, so they can reverse it. And that's a very interesting way of getting through a deadlock. So one party wants the other party to take an affirmative action. That party can choose to take that action or reverse it and say, we actually want the other party to take that action, and then that party's bound by that. So deadlock clauses are valuable tools. They do come with significant repercussions. So one could say that one is gambling if they do proceed ultimately, and they put the other party in a position to take an action. But if you're the initiator, even though you're making a demand for a buyout, you might be the one being bought out. But if they come back to you and say, actually, I want you to buy me out, they're going to be forced to do that. So something to take into consideration as we move forward. Okay, so moving along, valuation clauses. So we already talked about this to an extent. Valuation clauses certainly do provide a lot of clarity. Predetermined formulas for buyouts combined with agreed upon appraisers will reduce disputes and make outcomes predictable. And why is this important? Well, it's very important because if we can agree on exactly how the mathematical compounds are going to look, and even better, if we have valuators or appraisers already determined and in place, well, then guess what? We just saved a heck of a lot of time, of money, of expense, of back and forth over who's going to do the valuation, over how the valuation is going to be determined, over whether or not we're doing one valuator, two valuators, three valuators. And ultimately, we put us in a position where we hopefully can reach some sort of protracted buyout without having to go through the whole litigation process. So when you have these valuation clauses as an opportunity for you, it's really important that you review them, you edit them, you make sure that they're as clear as possible, and that they contain as much direct information as possible so that you're in the best position you can be in to know that if there is some sort of dispute leading to a buyout, or if you have a buyout election clause, you can proceed to the next step without a litany of confusion. And just about every litigator will say that yes, seeing that information in an operating agreement is ultimately can be the difference maker between getting something done and wrapped up fairly quickly versus going through a long process of back and forth that lead to dissatisfied clients, frustrated lawyers because they're trying to get to a point where we can even decide who the evaluator should be, but the clients dislike each other so much that ultimately it's so difficult just to get from one step to the next. And now just some additional considerations. And as you're seeing, a lot of this now really has to do with the operating agreements and construction itself. So these are some things to consider, especially as a minority owner, that will put you in a better position than you would have been in had they not been there. It doesn't mean that there will be no oppression. It doesn't mean that you will be treated unfairly or locked out of the company. But the more protective clauses you have in an agreement, the more you can assert various causes of action in addition to the oppression claims. And so in this situation, confidentiality clauses and non-compete provisions can be highly valuable for you. And why is that? Well, confidentiality clauses will protect sensitive information of the company. They often will include trade secrets of the business, so like client lists, like the formulas, if there's a patent or some sort of IP of the business that's protected. It could certainly include the means by which an operative functionality of the company works. If there's software involved, it's certainly going to include code. And it limits post-exit competition as well, because confidentiality provisions tend to survive the termination or ending of the ultimate agreement itself. And so in other words, if one party's bought out, they are still going to have to be in this situation where the party that's bought out will know it will be subject to a confidentiality clause and vice versa. So confidentiality provisions are very important. Of course, those align with NDAs. They tend to be very similar. Sometimes there's some nuances, but having those provisions in your operative documents are imperative. Also imperative to ensure that those provisions survive the termination of the company. If it does terminate or liquidate, we want to maintain confidentiality, and also if a member leaves, maintain that confidentiality. And if there's a reason not to, then that's something that can be put in a carve-out as some sort of separation agreement, which would also include a membership redemption document as well. Non-competes, also very valuable. Now, yes, it's true that a fiduciary breach would take place. An oppression claim would be viable if you have a member or members that have decided to ultimately leave the company and start a competing business or do something in competition. And they might take the client list, the customer list, the vendors. They might take marketing data and use it for their own personal gain outside of the company. They might try and disguise that they're doing this by setting up an entity and not disclosing who the actual ownership structure is. A non-compete provision is going to give the minority owner and the company itself in a derivative action the ability to expand the claims against the bad faith actors. And of course, the non-compete provision needs to be reasonable in scope and in duration, but nevertheless, they're still enforceable. Depending on your state, California obviously has become a different scenario. And I believe Washington State, too, has also shifted their tone on these types of clauses. But nevertheless, non-competes are still enforceable depending on the means by which they're structured. And there's been a lot of, there was federal statutes, a lot of stuff has been in the news about these, but as of now, they still have some teeth. Very important to have. And I would also just add as an addition that when you're dealing with non-competes, it's always a good idea to have that liquidated damage clause ready to go. And what do I mean by that? Liquidated damages provisions ensure that there is some sort of ability to collect a monetary amount in the event of a breach. So imagine a minority shareholder being able to sue a majority owner for not only the fiduciary breaches and the oppression, but also for violations of a non-compete, and pursuant to their contract, being able to enforce a penalty of, or I shouldn't say penalty but a monetary equivalent of either $10,000 or $50,000 or $100,000 or whatever it may be per occurrence, so per breach of the agreement. So per client that they've taken and are now working with, there is this liquidated damage clause that entitles the litigant to a collection of a specified amount. This is potent as a deterrent. It's also potent as a tool in litigation, because if you're in the minority, well, you know what? Not only do you recover general damages that a court decides you're entitled to, but you get to recover these liquidated damages as well. So having these types of provisions and agreements are very important, especially when minority owners are involved. So it's something to consider as you draft documents concerning minority owners. Majority owner perspectives. So just to focus a little bit on the majority owner perspective overall. If you're a majority owner, you're likely more involved in management, and therefore what you want to do is ensure that you're avoiding liability and that you're able to preserve control of the business. So majority owners need to balance control with fairness, transparent governance, adherence to agreements, and respecting minority rights will reduce liability and maintain operational stability. And when we're dealing with majority owners, one of the big questions that come up is they tend to feel that the minority owners are basically, over time, the majority will tend to feel that a minority owner or minority owners really aren't contributing to the business the way the majority owners are. And that's not so unusual. That becomes a consistent theme that we've seen with majority owners. And what we find out is often they've received a demand letter or they've been sued because allegedly they've done something that's ultimately limited the rights of the minority owners. And what we tell them all the time is to be mindful that a minority owner, even if they're a small shareholder with a tiny piece of the business, they still have rights, and the majority owners are absolutely obligated to adhere to those rights. They must produce documents for inspection. Now, those need to be reasonable. They arguably can't seek to harass or to continue to make demands that would be so overwhelming to the majority that they can't even operate or function and manage the business. But as a majority owner, it's important to not only be mindful of these things, but to paper and document as well, but to be mindful that just because a minority owner is a silent investor or a minority owner has sort of done less on the day-to-day, there might be justifications to, for example, terminate a minority owner's salary, but probably not ever a justification to not give them their distribution when you're taking your own. And you also have to be mindful of the same things that we talked about that the minority owners need to document. Are you increasing your salary for the sole purpose to essentially lock out or diminish the takeaways from the minority owner? If you're doing that, there's a potential issue and problem here that you're going to have to deal with. So you need to be very careful as a majority owner. And we do see a lot of issues where the minorities were previously salaried employees and they get terminated. Now, when you're issuing W-2s to minority owners, for those of you that are employment attorneys, this raises a whole litany of new issues that you need to be mindful of, because those protections that are afforded to employees might just extend to those minority owners if they're a W-2, and they certainly or most likely will, depending on the specific circumstances. So when you're dealing with that, you not only need to be mindful of your operating agreement or the statutory authority surrounding it, but you're going to want to discuss with the Labor and Employment Council what potential exposure you have, if any, based upon the means by which you're terminating and the justifications for doing so. Always important to be mindful of this, always important to focus specifically on these types of issues before taking definitive actions that will harm the minority. Okay, so balancing efficiency and protection. When creating these operative documents, make sure that you avoid overly restrictive provisions. You'll want to ensure fairness. And so while protective clauses are very good, especially representing minority owners, too many protective clauses can hinder decision-making, but then again, too few can lead to oppression claims. So the goal is simple: efficiency without exposure. And basically, the balancing act we're really talking about is that we never want to overwhelm a document with too many restrictions, simply because if the business can't operate without concerns over needing to constantly go back to the document and review, there's going to be a bottleneck on the ability to flourish. However, you also want to kind of strike the right balance. You want to ensure that protections are in place, that a minority owner is not going to get bamboozled, that they will have an ability not just to bring a common law oppression claim, but be able to refer to a number of strict provisions in the operating agreements or the bylaws that protect them and allow them to pursue contractual breach claims. Okay, and proactive counsel's role. So as an attorney advising a client, it's imperative that you always try and advise a client before disputes arise. And what we mean by that is that if they relay any information to you that seems like it's fuzzy, probably best to get them to address things right away with the majority owners or as soon as possible. So that way, if there's an ability to stymie something that's growing or something that's being unsaid, maybe they can do it. Often they can't, but maybe they can. So that honest, direct dialogue and conversation, we always like to encourage, especially when there is no real dispute yet, but they're starting to talk to counsel to see, should I do something because there's a little bit of internal friction. Have the conversation, document the conversation, make sure you're asking the right questions, know your rights, and ask questions aligned with those rights. Periodic audits. Focus on periodic audits. It makes sense to ensure that quarterly, it could be biannually, but put it in the operating agreement. Quarterly rights to inspect books and records, to receive financials, and to be kept abreast of developments within the company. So as attorneys, counsel should review agreements periodically, advise on governance compliance, and anticipate potential conflicts. Proactive strategies often save time, money, and relationships. And finally, key takeaways. Minority rights are layered. They're layered amongst fiduciary rights, contractual rights, and statutory rights. Early identification of red flags is critical, especially by counsel when having these discussions with your clients. Valuation disputes require clear agreements. Judicial remedies exist but are costly, and drafting protective agreements prevent most disputes, so that is the absolute best thing you can do for your clients at the beginning of a business relationship. We are out of time, so I'm sorry we won't be able to get to questions, but I want to thank everybody for taking the time. Once again, if you have any questions, you can contact me, Ross Pitcoff, at ross@pitcofflawgroup.com, and we are the Pitcoff Law Group. Thank you very much.
As stated during the beginning of this